Well, employers have reported that they are increasingly dealing with employees making workers' compensation claims for stress and anxiety arising from workload pressures and challenges employees say they're encountering in their jobs. Joining us for more is Joydeep Kaur from People and Culture Strategies. Joydeep, good to catch up with you. So, is this a recent phenomenon? Why is this the case?
Yeah, so I think we've typically looked at workers' compensation as something that is triggered when someone sustains a physical injury in the workplace. So you injure your back operating a machine, or you sustain some other kind of injury to a limb. What has changed a lot, probably in the course of the last 3 to 5 years, is that increasingly we are seeing workers' compensation claims that have been brought in the context of an employee feeling a certain level of stress and anxiety as a result of what's happening to them at work. Now, sometimes that is because they feel that there's been an incident, or there has been an alleged incident, for example, a bullying or harassment or something like that. But something that has shifted quite significantly in terms of what we're seeing with our clients is employees alleging that the workload pressures, essentially what their employer would presumably argue they've been engaged to do, are things that are causing them to feel stress and anxiety, and they are seeking to get compensation for that particular injury, as they are asserting has happened to them, because they're linking that to the workplace. So that is quite a significant shift, and carries with it a whole heap of problems and potential ramifications for employers and managers and how they go about dealing with it, which is extremely significant.
Yeah, so what are those ramifications there for the employers?
Well, the first thing I think is that employers naturally respond to this from the perspective of, what is the inconvenience to us right now? What are the things that we're going to need to do to keep our business, keep our operations going? Because essentially a person has said that they're injured, effectively they can't do their job, but they're not resigning, so they're still on our books. We still need someone to do that particular job, or attend to those particular duties. Should we rehire someone? Can we rehire someone? Can we ask questions about when this person's going to come back? So there's all of those operational and functional concerns that the employer understandably has. And then separate to that, very closely linked to that, is the process that's going to be conducted by the workers' compensation insurer, over which the employer is going to have very little control. So this third party to whom you've been paying your premiums, or in respect of whose support you've been paying premiums for perhaps many, many years, is then going to make their own assessment as to whether or not that particular employee did sustain a work-related injury, how they're going to manage it, whether there's going to be any compensation that they're going to provide to that particular person. So these two processes working in parallel, often issues that an employer will be dealing with for the first time, lead them to making some judgment calls and some decisions that often make the situation worse.
So, what is the nature of these complaints? I guess it would differ. You've got obviously compensation or complaints made in regards to mental duress, bullying, and the like. But there's also physical compensation as well.
Well, that's right. So you can say, look, and just to give you a pretty real example, dealing with a case for a client at the moment where a fairly senior executive who was recruited just completed that individual's probationary period. Fairly shortly after that probationary period, has alleged that their workload was too much, and has had their partner notify their employer that they're going to be making a workers' compensation claim. They tender a certificate of capacity to that particular effect. And so the employer is dealing with a situation. Really, we don't know what's gone on here. We thought that everything was fine. We'd hired this particular person to perform this important function. We didn't really have any sense that they weren't coping. We made the decision to have them pass probation, and now they're gone. So what the employer is dealing with here is, well, how did all of this happen? What is in fact wrong? Was it something that we just have no visibility over? Was it something that is more a background issue or characteristic, or about the history of the particular individual? And so in terms of how much of this is physical, how much of this is mental, the employer has lost visibility at this particular point in time, in this case and in many cases, as to what has actually transpired physically and or mentally or emotionally or intellectually to this particular worker, because they've just they've just gone off, they've made the claim, and they've ceased to have contact with their particular employer. So this is what contributes to the nebulousness, if you like, of these kinds of processes.
So, Joydeep, how can employers get on the front foot, perhaps anticipating this, perhaps, or at least being proactive about it?
Yeah, I think, and it's a common theme, Andrew, that we talk about a lot in the discussions I have with you, that communication between a line manager and an employee, regardless of the seniority of that particular employee, is so critical. Now, if allegations are made that a person's workload is contributing to stress and anxiety for them, there are a number of things that need to be looked at. Firstly, a proper assessment of whether that workload is fair and reasonable to be asking of someone. It may be that it is, and it may be that it isn't, but that's something that an employer really has an opportunity to make its own inquiries in relation to and pressure test howsoever it sees fit. On the other side of the ledger is, of course, the suitability of a particular candidate. I mean, ultimately, the recruitment process is there and should be there for employers to make an informed decision as to whether an individual that they are seeking to hire does have the skill set to execute at the level the employer needs them to be executing at. And that involves, most critically, will they be able to handle the workload? Now, that is something that you can ask questions about. That is something that reference checking is going to be important in relation to. But that most critically, that first period, the probationary period, that first 6 months or 12 months or whatever it's going to be, that's the time that the employer should be making its own assessment as to whether or not the particular candidate is in fact able to do what the job requires them to do. So they're the key actions that I'd be recommending that employers take and incorporate into their recruitment and employment practices to get on the front foot.
Joydeep, is it realistic that once a employee makes a claim that they can return to work? Clearly there'd be some lingering resentment there.
Exactly. In my experience, I'd probably say less than 5 or 6% of cases result in those kinds of circumstances where, the injury is dealt with, the claim's dealt with, and the person returns to work as normal. It's exactly as you say, Andrew, that these situations cause some resentment, cause some questioning on the part of the employer, perhaps as to the suitability. There's often issues of trust being broken. Rightly or wrongly, perceived or actually, by virtue of someone externalising a matter such as this. And a manager will say, well, look, why didn't you talk to me about your workload? We could have worked through that together. Instead, you've gone down this path of going external. And that's often seen as a breach of trust and something that can be very hard to come back from. So unsurprisingly, it's a very small minority of these cases that end well.